Yes, good evening to everybody. Welcome to the All India Bar Examination 16th Cohort 2021, whose exam is going to be conducted on the 31st October 2021. Yes, I believe that you are with me and I am with you. For the confirmation that please read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Yes, V. Venkateshwar Rao. Please unmute and read what I posted on the screen so that I could know.
Sir, All India Bar Examination, 16th, 2021.
Yes.
When factory act.
Okay. Now it means that you are hearing me and I am hearing you, isn't it?
Yes, sir. Yes, sir.
Yeah. Now coming to the certain questions that I prepared based on the that is the 15th cohort examination. See, the 15th cohort examination was paper here I shared. See, I'm sharing with you now. This is the 15th All India Bar examination. One of the set of this is set A question paper. So where they have mentioned section 66A, capital A of the Information Technology Act was held unconstitutional in the case of dash. They put it over there. So the A option is Justice Case Puttaswamy versus Union of India, and the B is MP Sharma versus Satish Chandra. C. Shreya Singhal versus Union of India. D. Gagan Harsh Sharma versus the state of Maharashtra. So these are the four options are given, and this is a very famous case law where section 66 capital A was struck down as an unconstitutional. Yes, now you tell me that what was that case law where it is struck down. Yes, try. I think that you could see the screen which I posted on this, isn't it? Yes, anyone? What was the answer for that question? The first question, that is the All India Bar Examination 15th cohort question, that is. Even though it is wrong, it doesn't matter, you can shoot it. See that I could see that one Dr. Saab is present, and the Kumar and Ramesh is present, Sai Kirtan is present, Pushpalata is present, Singham Janardhan is present, V. Venkateshwar Rao is present. Anyone can unmute and give me the answer what is the right case law where it is decided that 66A Information Technology Act, it become a void in one of the case law which I just referred, A, B, C, D. Hurry up, even though it is wrong, doesn't matter. You don't lose the marks. Yes? Anyone can unmute and give me the answer. I believe that you are hearing me, isn't it? Kumar Ramesh, you unmute and give me the answer. What was the right answer for that which I just now read? I did not get the reply. Does it mean that whether you are hearing me or not? Why you are taking that much time to give the answer? Because this is the second time or third time that we did the case law. Because when I was dealing about that, there also there I said 16.6A was the Information Technology Act was held unconstitutional in the case of. Yes, it's a C. But why you are keeping quiet? Yes, I know it is a C. You gave the answer, but my point is why you are taking that much time to say the Shreya Singhal versus Union of India? Because it is a repetition question law. The next question is, shall I proceed or you want to say anything?
Proceed, sir.
Okay, thank you very much. Thank you very much. So second question is, a teacher is not a workman within the purview of the Industrial Dispute Act held in the case of, number A, the Workman's versus Greaves Cotton Company Limited and others. B, John Joseph Kokar versus Hadang, BS and others. And C, A, Sundarambal versus Union of India, Union of Goa. D, Dinesh Sharma and others versus state of Bihar. These are the four case laws where a teacher is decided that is not a workman within the purview of the Industrial Dispute Act. Yes, what was that case law?
C, sir.
Is a Sundarambal versus Union of the government of Goa?
Yes, sir. C, sir. Yes.
Okay, let me check whether you are right or wrong, because I have the key also with me. So let me check the key. Whether you are right or not. See, what is the question? The question number that is. See, when you say the question is 2 means C, then 2C is the right answer for that. What you said is the right. 2C is the right answer. Okay, can it is down. Yes, 2C is the right answer. It is coming again. Okay, that out close down. Then this has to close down. Okay, 2 are open over there. Okay, now it is because this is the first time that I'm operating. That's why it is taking time. Otherwise, I could see here the answers are very much here. Okay. Yes. So the answer is C. That is A. Sundarambal versus Union of the versus Government of India. There it is decided. But the similar type of the case law that I already dealt it earlier, and I am sure that you could know it. So this is the question paper which I want to deal it in today class. So unnecessarily these are open. Many are opened. So let me close down some of them. Okay, so now in these lines, see in another we'll see it. Third one is according to the Factories Act. Number A, child means a person who
Answer
has not.
A, sir. A.
Please, completely you see. A child means a person who has not completed his 5th year of age. That is A. B. Child means a person who has not completed his 14 years of age. C. Child means a person who has not completed his 18th year of age. D. Child means a person who has not completed his 16th year of the age. Now what you said is very much correct. That is the A is the right answer. Of course, you do have the yes. You do have the knowledge is there. That's why that you can give that that is the right answer. Yes, you are right. It is an A answer is the right. So I prepared in the same lines after reading the things. Okay, now you tell me when Factory Act 1948 came into effective or came into force on dash 1st January 1949, B 1st February 1949, C 1st March 1949, D 1st April 1949. Which one is the right answer for the among the four for the question when a Factory Act 1948 came into effect or came into force on? Yes, give me the answer.
C, sir. 1st March.
Are you sure? See, when comes the doubt to our, then what do you have to do?
40.
When it comes to the matter of doubt, what do you have to do?
48, here is 49.
yeah. See, when you doubt, no, it is clearly written over there. 1st April 1949. Is it visible to you or not?
Yes, sir.
The Factories Bill have been passed by the legislature, received an assent on the 23rd of September 1948. It came into force on the 1st April 1949 as the Factories Act 1948-63 Act of the 1948. This is the right answer. So now the answer is first
D. D, sir.
yes, it's the 1st April 1949 is the answer. Okay, now next question is. Yes, can anyone mute and unmute and read what is the next question? That is the Factories Act. Yes. Hurry up.
The
The Factories Act.
Yes, anyone one can lead. One can lead. Don't worry.
The Factories Act 1948 and the Act number dash of 1948. A 60, B 61, C 62, D 62.
Just before you have seen on the screen, just before I have shown on the screen, I don't know whether you remember it or not. Yes, what is that screen? It is there. What is the number is there on the screen?
63.
63.
63
of 1940.
Yes, I thought you saw the answer, but
No,
when
sir.
I asked the question, he did not give the answer. So what is the exact
D.
here is the D is the 63 of the 1948, where the act number. Okay, now based on those lines also they prepared this one dash. Inspector in Chief of the Bombay Cotton Department in his report in 1872-73, first of all raised the question for the provisions of the legislation to regulate the working conditions in factories. The first Factories Act was enacted in, I repeat, the first Factories Act was enacted in dash first dash John Murray and 1880. Second, Major Murray, 1881. C. Joseph Murray and 1880. D. Major Murray and 1880. Which one is the right answer among the four? A, B, C, D. Yes, even though it is wrong, you can show.
B, sir.
B, Major Moore and 1881.
Major Moore and 1881.
B. Major Murray and 1881 is the right answer. It is the Inspector General of the Bombay Cotton Department at the time that when the report in the 1872-73 first of all raised the question for the provisions of the legislation to regulate the working conditions in factory. The first Factories Act was enacted in, that is Major Murray and 1881. That is the right answer. That is the B is the right answer. Next question. In 1844, the Parliament passed a further Factories Act, which effect was the first Health and Safety Act in dash. Is it in England? Is it in Britain, East India Company, or India?
East India Company, sir.
Intentionally, I kept that one wrong.
D. India.
Wrong.
Britain.
Right. It is the Safety Act in Britain that is the wrong. The intentionally I created the England and East India Company and India so that you will be deceived. Okay, that was my point. It is in a Britain. The feedback, if you have to see it, in 1844, the Parliament passed a further Factories Act, which in effect was the first Health and Safety Act in Britain. Okay, next question. The state legislature passed the 1893 Factory Act, which was prohibited the employment of the children dash. Which one is appropriate answer? Number one, A, below age of 14 years. B, within age of 14 years. C, under the age of 14 years. D, up to the age of 14 years. Which is the appropriate answer for that one?
C, sir.
It is underage. That is the exact wording should be there under the age. That is the wording that you use. Not below age and not within age, not up to the age. So that is the thing. So now, according to Factories Act, a child means a person who has not completed his 15th year of the age. See, here I prepared exactly the same which is given over there. With that question, see, I developed all those things because it is very near to it. So now this answer, anyone can give me that that is the Factory Act means the child is below the age of?
Yes, sir. 14. Sir, 15. 15, sir.
Just before that, we read the case line, the 15th
Yes,
cohort
sir.
examination, the first, the second case law that we read it, where the first case law shows that the 66A is struck down. That is 66A of which act? Anyone? Supplementary question. Yes. The 66 capital A that is struck down in one of the case law that there Shreya Singhal versus Union of India. In which act that is 66A belong?
IT Act, sir.
Why you are taking that much time to say? It is Information Technology Act. Of year?
Act.
Year. Information Technology Act. Year.
2000.
Suppose if I ask, what is the act number? What is the act number? Sir, we only, sorry, 2000 కొట్టు పెట్టాం గొప్పగా సార్ మళ్ళీ act అంటే in the exam they do ask in a such a way also. So what is the act number? See, when such a thing would be there, then in Information Technology Act, you can make it out. Act number, you can make it out what it is here. It is automatically come over there so that it becomes a. See, this is the Information Technology Act 2000, also known as the IT Act 2000, and IT Act is an act on the Indian Parliament number
21.
21, sir.
number 21 2000, notified on 17th October 2000. So not only that you should remember the year, you have to remember the act number as well as the when it is coming to effect also. Sir, how could you remember it? No. Once you develop the equation, I am sure that you will strike the right answer. It is the primarily law in India dealing with the cybercrime and electronic commerce. In addition to the Information Technology Act of the 2000, what are the other central act could be used over there in the disposing the cases? Anyone? I already framed this when I was teaching that. In addition to the Information Technology Act, to curb the cases, to file the cases, to dispose the cases, what are the other central acts can be used, are applicable?
Cyber laws.
Cyber laws, did you have an act? Cyber laws act is there anywhere? Sir, book is there. I told you that we use Indian Penal Code 1860 Act number, Indian Penal Code Act number 45. Am I right? In addition to that, we use law of evidence also as an adjective law. So these are the two major laws that we can be used when Information Technology Act is silent. I discussed this thing, but I don't know whether you remember it or not. Okay, now let us come to the next question. No female child shall be required to or allowed to work in any factory except between 7 a.m. to 7 p.m., 6 a.m. to 7 p.m., 6 a.m. to 6 p.m., 8 a.m. to 6 p.m. Which one is the right answer among the A, B, C, D?
D, sir. 8 a.m. to 7.
Right, yes, Singham Janardhan, you are right. It is the D, 8 a.m. and 7 p.m. That is the where a female child shall not be shall be required or allowed to work in the factory except between the 8 a.m. and 7 p.m. Okay, now next question is adolescent means a person who completes his dash. Hence, he is someone who crosses the age of the child, but is not an adult, but is said to be adolescent. A, 15th year of age, but not his 17th year. B, 15th year of age, but not his 18th year. C, 15th year of age, but not his 19th year. D, 15th year of age, but not his 21 years. Which one is the right answer among?
B, sir. 15th year of age, but not.
You are
B.
right. Both of them. Dr. Saab is
B.
right and Pushpalata is there. And Singham also giving the same answer, I believe. That is the B is the right answer. That is the 15th year of age, but not his 18th year of age, where you can say adolescent. When you say adult, according to the Factory Act 1948, what is the definition of the adult? Yes, anyone? See, we have seen child. A child means below the age of 15 years is called child.
50.
According to the Factories Act 1948. Okay. But the same act, adult, you will say. Because it may be asked in any
Above
form.
15. Above 15 years, sir.
No.
Above 18, sir.
Above 18 years. That is the answer.
Above 18.
Yes,
Answer
above
ikkade
18.
undiga.
Yes. That is the answer for that one. So why I am giving all those things is, yes. Dr. Sir, you want to share something?
10 to 19, sir.
Okay. Right. Appreciate. I appreciate.
It is for adults, sir. So
Yes.
automatically adults, sir. After 18th year.
Yes, you're right. See, why I am asking all those points means in the 15th cohort, it is asked, what is the child means according to the factory arts. So with this, I developed what is adolescent. Then I made the supplementary question, what is adult? And I made the female workers, the child who are not supposed to work over there. And these are the things which I developed by just reading that case law. Then we will see that, yes, when we will see the next one is, we see in which section of the Factory Act, I repeat, in which section of the Factory Act, can you say CRECHES, crochet or crochet? Means where the children will be taken care of, those who are employees whose children will be taken care of in your room. Crochet or crush.
Crochet, sir.
Yes, what is that? How do you pronounce
Crochet.
it? Crochet is mentioned. Yes. So here I have made it. Section 11A.
Section 48, sir.
Yes.
Section 48, sir.
Appreciate. It is a D. That is the section 11, capital A of the Maternity Act safeguards the intent of dash. That is section 48 of the Factories Act 1948. Yes, which requires factory with more than 30 female workers to have a crochet. Please unmute. We are speaking to somebody else. So now, with this, I can develop another question. What I say, supplementary question. How many female workers should be present over there in a factory or institution where crochet becomes must or mandatory? Just now you saw the question, you read it. And there I mentioned the female members working in a particular organization where it becomes a mandatory to keep the crochet. Yes, answer? 30,
30, sir, 30.
40, 50.
30.
See, already I have given
30.
here, I don't know, here. See, more than 30 female workers to have crochet. So, suppose if I make you confused, instead of writing the more than 30 female, I wrote the 35 female, 35 males. It is nowhere concerned with the how many males are there. You write some 40 or 45 or 50. I wrote only males, not females. But one, I wrote the female, but I mentioned the number 35. At that instance, they say more than 30 means 35 also included over there. Or I can frame the question, none of the above. If you happen to see my earlier questions where that I mentioned these things, how many females should be there and what would be the maternity leave will be awarded? Yes, what is the present position of the maternity? Anyone? I say, what about the present position of the maternity leave?
6 months, sir.
But why you are taking that much time? Sir, I want to take the time, whether you are asking for the question for the man or woman. Maternity leave, the woman is entitled to get it. But simultaneously, the man also going to get something. How much maternity leave will be awarded to the man?
Paternity leave for
Yes.
men.
Yeah, we should say, right. I appreciate it. The paternity leave will be awarded to the husband.
Men.
Yes. I raised this as such a question in my. So, to make it clear how much the paternity leave would be there, we can make it out. How much HOW, how much MUCH paternity leave will be sanctioned or allowed
10 days.
for
10 days.
10 days.
Yeah, 1 week or 10 days. I have the doubt. That's worry.
10 days.
So how much maternity leave will be banned or allowed for a man? So Maternity Act 1961, it will clearly says that how many days maternity benefit for that one and how many can a maternity leave. There is limit to maternity leave. But what about the man? Is it 10 days? Where it is written? And which section it is written? Section also we have to know it. If it is section is there, find C. Check here, C. Yes. See, we speak about the maternity leave. So which section deals with the maternity leave? especially leave, the maternity benefit they have given here. So let us see the maternity leave. Which section gives maternity leave? Suppose if they ask such a question, of course, leave for the miscarriage is there, which is said in the section 9 of the Maternity Leave Act. But we want the maternity leave is in section 9 to leave with the wages for the maternity benefit for the maximum period of 1 month. But whom it is? Section 6, as the case may be under the section 9 of the wages at the rate. No, this is not the right answer. So leave for the miscarriage is given in the section 9, and leave for the illness, no, arising out of the pregnancy, delivery, premature with a birth child, or the miscarriage is given in section 10, and nursing breaks is given in the other section. See, right to permanent of a maternity leave, it is given over here. Subject to the provision of this act, every woman shall be entitled to and her employer shall be liable for the payment of the maternity benefit as a rate of the average daily wage for the period of her actual absence immediately preceding and including the day of her delivery and the 6 weeks immediately following the day. See, this is the 6 weeks means 1.5. This is the unamended version is there. It is an unamended version, but now it is a 6 months maternity leave would be given. I believe that is the 10 days or a week is the paternity will be given over there. So subject to the correction that we will go further. Okay, next. Yes, which amendment of the Arbitral and Conciliation Act? I repeat, which amendment of the Arbitral and Conciliation Act was a wolf in a sheep's clothing? Amendment, that is. In which amendment it is? A. India's Arbitration and Conciliation Amendment Act
D,
of
sir.
2019.
D.
The answer is India's Arbitration and Conciliation Amendment Act of 2021. It says that it's a wolf in a sheep's clothing.
Yes, sir.
That
Ashish
is the
Dholakia Ketan Gaur.
yes. So that was the thing which is made it clear, because I got this idea from this act here. See, the unisexual model law and rules don't become a part of the Arbitration Act. I repeat, the unisexual model law and rules don't become part of the Arbitration Act so as to become an aid to constitute the provision of the Act. It was held in the case of A. The Union of India versus East Coast Boat Builders and Engineers Limited. B. Union of India versus MC Mehta. C. Tata Press Limited versus Union of India. D. Union of India versus Indian Change Chrome Limited. Yes, now you
B. Union of India versus MC Mehta.
So let us check who is right. Whether
D,
who
sir.
is right, we will check it now. It is the key answer key. It is here. Yes, that is which number that
MC
is?
Mehta.
No. What is the number question that I read it just before?
B.
Question number.
Don't
Question
remember.
number. Here, you did not know the question number. It is here. See, it is the fourth question where I read it here. So here the fourth question, when you say read, then the answer is fourth question is the set A. See, set A that I am doing, A is the right answer. Fourth A is the set A is the right answer. That means it is the
Wrong.
Union of
Union
India
of India
versus
versus
East Coast Boat Builders and Engineers Limited. So that is the very right answer for that one. The next question they asked is the fifth question. According to section 7, subsection 4 of the Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in dash. That is a document signed by the parties. B, an exchange of letters, telex, telegrams, and other means of telecommunication which provide a record for the agreement, and that C, an exchange of the statements of the claim and the defense in which the existence of the agreement to alleged to one by one party and not denied by all the other party. Then the D is all the above.
D, all the above.
Let us see that whether your answer is right or wrong. C, that is the sixth, that is the fifth, whether the answer for the 50 is D, that is the set of A, that is you are right. So that is the right answer for that one. So based on those lines, I developed the above question, that is the which amendment of Arbitral and Conciliation Act was said to be known as a wolf in a sheep's clothing. That means it is the India's Arbitration and Conciliation Act of the 2021, the amendment which is made over there. Then I also developed, of course, supplementary question also I can make it out. The India's Arbitration and Conciliation Act, actually, which is the year it is passed? Yes, anyone? India's Arbitration and Conciliation Amendment, not amendment, only act, in which year it is passed? So again, the question comes.
1996.
Yes, please tell me. India's
1996.
Arbitrational and Conciliation Act, when it passed?
1996.
See,
1996.
it is very much clearly given over here. The Arbitration and the Conciliation Act 1996. See, the supplementary question they may ask in that way also. What is that? They say, I already told you that it is 1996. Then the next question is going to be asked is when it became an effective, number one. Number two, what is the act number? Yes, anyone can say, what is the act number? It will be given in the act number in, of course, here the total picture is, here it is given. What is the act number? What is the act number?
26, sir.
26 of the 1996. So, when you want to make a question, the Arbitration and the Conciliation Act of 1996, it is made over there, but the Act number 26 of the 1996. Then when it is come into existence, that is also very important point that one should have to remember. Suppose if they want to say is that the Arbitration and Conciliation Act 1996, no doubt it was there. But what are the rules and regulations adopted in the Unisexual? So the next question is Unisexual conciliation rules in 1980, it is given over there. The rules. So it is based on whom? The preamble it is clearly given. But whereas the United States Commission on the International Trade Law, that is the Unisexual, has adopted the Unisexual model law on international commercial arbitration in 1985. So that is a model. We have taken the law of the international commercial arbitration in 1985. Then this act was passed by following the rules of the 1980 of Unisexual conciliation rules. So in this way also a question may be framed, and it also clearly given, it is extended to the whole of India, because a question once it is given where we are discussing about the Information Technology Act, where we are discussing there the extent of act I gave the except the Jammu and Kashmir I told, and except the Nagaland or so and so I told over there. So in the same manner, the supplementary question, whether this act will be extended to the whole India or except Jammu and Kashmir, or except Nagaland and Haryana, Nagaland and Arunachal Pradesh, or except the some other point, they can ask it as a supplementary question. So what is the right answer for that one?
Whole India.
Whole India is the right answer. So this is the way one should have to develop the supplementary questions when you are making it. So based on that supplementary question, then I prepared the Indian Evidence Act, originally passed in India by the
See, sir.
yes.
See. Imperial Legislative Council.
It is a Imperial Legislative Council in 1972 during the British Raj. They passed. So I gave the option British Legislative Council, B Royal Legislative Council, C Imperial Legislative Council, D East India Legislative Council. So this is only I coined it, I invented it, I made it this question because you could not get it in other books. The reason is I took the idea from that books, then I developed and extended and expanded, and I developed these questions. So a question can be asked in a manner whatever he likes, because you can say that in the 360-degree angles, a question can be asked. Is it clear?
Sir.
Yes, sir.
ICS.
Oh, yes. What is meant by ICS?
When an IAS not was there, sir.
Okay.
Sir, ICS. That is
Okay.
Imperial.
Okay. So this is the way where one should have to frame the questions. Then next question which I framed is the most powerful type of evidence. I repeat, the most powerful type of evidence dash requires no inference.
None of the above, sir. D. None of the above.
See,
Because it's a
now-
direct evidence.
see, how could you know it is a direct evidence?
Sir,
Now, how could you get the idea
any
of direct
any
evidence?
evidence shows that direct impact has great values established and prove fact in issues.
Yes, yes, yes. That's the direct evidence would be there. I did not mention in the ABCD. I wrote the circumstantial evidence. I wrote the hearsay evidence. I wrote the corroborative evidence. Then I wrote the none of the above. So when I wrote the none of the above, perhaps you got an idea because in the other questions, there is no none of the above. So to make you deceive what I do, in the upper question also I wrote the none of the above, then one of the answer is the right answer. The subsequently that I wrote this question, your idea will not come out. Why? The none of the above is the right answer. That means I indirectly gave an idea to you. I repeat,
Yes.
I indirectly given an idea to you to go directly and strike at the none of the above. Because your equations in your mind definitely will teach you your equations, your what I say in computer science terminology, program, your program that you already fixed in your brain. So that's why immediately you will go to. So none of the above is the right answer for this question. The reason is it is a direct evidence, requires no inference. That is a powerful type of evidence. But other type of the evidences are called circumstantial evidence, hearsay evidence, corroborative evidence, and of course, then indirect evidence is there. So that is the another word we can use. So now the rules are followed in the law of evidence. I repeat, the rules are followed in the law of evidence. Among four, one is not relevant in it. So what is not relevant in it? Number A, inadmissible. B, authentic. C, complete. D, reliable. This is I only coined it. You don't find get any one of the book.
B, sir. Authentic.
Repeat.
B, sir.
Authentic, sir.
Professor Hussain, students never give the answer in that style.
Be authentic. Answer is be authentic, sir.
No. Second option.
Sir,
Inadmissible, sir. Maybe.
How did you know it is inadmissible is the answer? Can you tell me? What
sir,
made you
because
think
the
inadmissible?
only three rules are relevance, materiality, and competence.
Your sixth sense will give the answer immediately when you read the four options. Your sixth sense, your program will definitely go and click inadmissible might be the thing.
Yes.
So automatically, how you developed it? Because I trained you to think in that way. That's why I told
Evidence
you,
is shown to be
don't
relevant,
take any
material,
books to the bare axe in the examination hall. If you take it, you will become a parasite. So the answer is, there are total 5 rules are in the law of evidence: admissible,
yes, sir.
plus
Authentic,
believable.
complete, reliable, and believable.
Now I made another question with this one. What is the right sequence of the 5 rules in the law of evidence? There are 5 rules are there in the law of evidence. What is the right sequence of the 5 rules of the law of evidence? A, admissible, complete, authentic,
sir.
reliable, believable.
B, sir.
What? Repeat.
B. B, admissible, admissible, authentic, complete, reliable, believable.
So now let us see whether you are right or not. See, I are given here. Now you compare which is right
I
and
told
which is
you,
wrong.
I told you.
Number 1, admissible. Number 2, authentic. Number 3, complete. Number 4, reliable. Number 5, believable. So the answer is
B, sir.
B. This is the right
B.
answer. This is B is the right answer. So a question will be framed in this way also to know how much that you could know it. See, I developed it because I read this question paper. Which question paper? This question paper, I read it. Then I thought, okay, we can frame the question in this manner. So now that is let's come to the sixth question. Waiver of right to object deviance from the arbitration agreement is mentioned under dash of the Arbitration and Conciliation Act. Section 7, Section 4, Section 20, Section 22. Which one is the right answer? Should, even though it is wrong, doesn't matter.
Section 7, sir. A.
Section 7A you want to say. Okay.
B,
Second
section
option.
4. B,
Section
Section
4,
option
sir.
is-
B, section 4.
4, sir.
So
Four,
people
sir.
say, many of them made, the majority of them say section B, that is a 4. Means let us see whether who is a winner here. That is the sixth question. Answer is, and here we'll say, sixth
Four.
question answer is B. This is the B. And now when you go to the sixth question answer is B, that means section 4, I believe the Bahubali and Singham, they favored the section 4. The other girl, they favored the section 7. So the right answer is B, section 4. See, they can ask in any manner, not only this one. So I can put any other question from the Arbitration and the Conciliation Act, then I ask you which section says. So this is an idea that I developed over there. Okay, let us go to the seventh question. Internationally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He will not be allowed to prove his word of title, which section of the Evidence Act is applicable.
Sir, can you zoom it?
Okay. Zoom. Let me check it. Where is the
There is 3 dots over there.
three
To your
dots?
right side.
No.
Upper.
I know only Zoom control plus. See, this I know only.
Yes.
You can use the
Okay.
control, then you
Okay.
add the plus, then automatically it becomes a bigger. See, I am not only giving you the legal knowledge, I am giving you also computer.
Knowledge. Knowledge.
Savvy. SAVVY. Only the Professor Hussain student will say computer knowledge. The other people say the computer knowledge. Other people say the computer application. But Professor Hussain students will say computer savvy. 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 Okay, now let us come to the point here. The seventh question answer is
C, sir. Section 115.
Yes, sir.
section 115, where it says, and what is the doctrine? Can you tell me this is doctrine? There is a doctrine also available over here. Once you say, this is my property, in fact, it is not your property. When you said, but later on that you acquired the property at the time of this transaction, at that instance, doctrine of, yes, what doctrine will say? Doctrine
Estoppel.
of estoppel. I appreciate.
Estoppel.
It is
Doctrine
the
of
doctrine of
estoppel.
estoppel will work over there because you said at the time you are not the owner of the property, but later the transaction comes over there, you become a owner of the property. At the time, you cannot take back your word, even though you are not the owner at the time. So here the answer is 7, you want to say C, is it?
Yes, sir.
7C. Let us check your answer is right or not. Yes, you are right, Bahubali. So now you are getting very nearer to the using your strategy, planning, programming, sixth sense to find out which is the right answer, which is the wrong answer by merely deciding on the 4 options which are given over there. Okay, now let us come to the next 8th question. Can anybody will read the 8th question? Unmute and read.
The Arbitration Act 1996 repeals A. The Arbitration Act 1940. B. The Arbitration Protocol and Convention Act 1937. C. The Foreign Awards Recognition and Enforcement Act 1961. D. All of the above.
So now,
D, sir. All of the
D,
above.
sir.
D, sir. D.
All of the above.
if I may be the
Because it's
examiner,
also Act of 1937 and 1961.
if I
Yes,
may
sir.
be the examiner, I never put the question in this way. Because
Okay.
in one way, in another way, you are feeding the student which is the right answer. I don't want to give in that way to feed the student to give the easy answer. Sir, sometimes you will give the easy answer because you will show the feedback on the screen. Mistakenly that sometimes we will pull it down, it comes over there, but immediately when I can notice it, then I will pull it down so that you could not see what I posted on the screen. But also that I want to know it whether you have the photographic mind or not. So now here the person has put the all of the above. I said I give all the three right, but one I made which is wrong. Then I will say which is not mismatched to this Arbitration Act of 1996. That is the question framing to the student where he can brainstorm it and come to a point. When he could not do so, then he will write the all of the above. So now I will test you whether your all of the above is right or not. That is the question 8. Then answer we are going.
D,
Question
sir.
8 answer D, all of the above. That means you have not got the knowledge in one way, in another way. By going through either you are using your own technique, mnemonics, or equation, formula, strategy, program. That is a very appropriate word. Program is an appropriate word because it is connecting by taking all the variables. All the variables that you applied, you developed a program in your brain. So go with the program mind to the examination hall, but not with the bare acts. Is it clear? Is it clear?
Yes, sir.
Yes. At any time it is going to be stopped over there. Then up to that extent that I will go to the next question. That is the 9th section 265 capital A.
Plea bargaining, sir. 21A of criminal procedure.
Even I did not read the multiple choice. You gave the answer. How you gave the answer? Sir, I read
Sir,
it,
plea
sir.
bargaining, sir. ऐसा नहीं है, sir.
No.
Actually, Chapter 21A of Criminal Procedure Act deals with the concept of plea bargaining itself.
Okay. How could you know that is the answer? Sir, did you read it somewhere or remember it? Or what technique that you developed to know the answer? Tell me. Share your views, share your strategy, share your equation, share your planning with our other participants. Please. Hurry up.
Sir, under Chapter 21A of Criminal Procedure,
I asked you a plain
1973.
question. I asked you a plain question. How could you come to that point? What is made you to think that is the right answer? Can you give me the equation? What equation? Sir, equation is nothing but, sir, I read and read.
Maximum period of imprisonment is 7 years, sir. That's what I thought. Because plea bargaining is mostly 265 to 267 that deals with the concept.
I want to know the secret. Now, 9th question, whether you said is a true or wrong, let us succeed. 9th question is D is the 9th right answer. Means plea bargaining the right answer. See how you developed. Now you share your views with the participants. So same strategy that you develop in your program by taking the various variables and inducted over there. Then when you see the 4 options, automatically your 6th sense will work. This is the right answer. Then immediately go and tick on it. Now, before I close it, let us see that whether I finish the 10th question or not. Security for the good behavior from the habitual offender is dealt under the dash, section 109, section 110, section 111, or none of the above. Tell me. Here, none of the above is given. Huh?
None of the above.
Are you sure?
None of the above, sir. It's 108 actually, section 108 of CRPC, but CRPC is not there. So
109 or 10, sir.
10.
108, sir.
B is the right
9.
answer. So you are wrong this time. B is the right answer. It is
10.
the
10.
B. 110 is the CRPC. Security for the good behavior from the habitual offender is dealt under the section 110 of the CRPC. Here he made you to fail because he has given none of the above, but the right answer is given over there. So this is the way where you can make it a point. Suppose the none of the above also given over there. Don't be very much